Ms Chamberlain.
Lords, my lady, before the short adjournment, I'd got to the end of my second head of submissions, which were the legal points under the Equality Act. Third head deals with the significance of the regulatory framework to the reasonableness of the adjustment. Now, there are two statutory instruments which are of relevance here, as you have already seen. The first are what we've termed the accessibility regulations. And you've seen those regulations. They deal, in general terms, with the dimensions of the wheelchair space and with ramps and other technical matters of that kind. But can I just show you the impact assessment which accompanied those regulations? You have that in Bundle 4, tab 33, MS 2109. Yes. What this is doing is it is trying to predict what the impact will be of the regulations.
Yes.
And in the middle of the page, you can see that an increase in the use of public transport is predicted.
Yes.
Part of the increase comes from mobility encumbered people, particularly parents with small children and pushchairs, which is an encouraging result, as it shows that an accessible service is of value to more than just disabled people. So that really goes to our point that when the accessibility regulations were introduced, it was envisaged and hoped that they would be of use both to disabled people and to other categories of mobility impaired people.
Yes.
Now, the accessibility regulations themselves were made under the Disability Discrimination Act, under provisions which are now to be found in the Equality Act. And as I've said, they prescribe the dimensions of the wheelchair space. They also prescribe, as I think I mentioned before, the wording for the sign that has to go next to the folding seats in the wheelchair space. And one sees that in Bundle 3, tab 25, MS 1658.
Is it in the, whereabouts do we find it in the full version of the regulations that we now have?
Oh, I see. I'll just see if I can find that. It's Regulation 3, paragraph 4. Sorry, it's not Regulation 3, it's paragraph 3 of Schedule 1 to the regulations, subparagraph 4, and it's on page 11 of the print. And it says, there shall be a sign on or near a seat specified.
Your answer to Lord Assumption's point.
Yes.
Yes.
So the word please is actually there.
Yes.
You are allowed to state words of equivalent meaning. I suppose a question might arise as to whether the omission of please kept the meaning or not.
These are the special seats. They're not the wheelchair space.
They're fold-down seats which people can sit on in the wheelchair space. But they're told, please give up this seat for a wheelchair user.
Forward-facing wheelchairs.
Yes. There's an equivalent one for rearward-facing.
That forbids supplementing that with, if you don't, you may be required to do so.
No, your Lordship is absolutely right. It doesn't forbid anything. It says that you must put up this sign, and that's exactly what we did. But insofar as the point is taken against us that the words we used lacked bite, if I can put it that way, the answer, which we think is a fair one, is, well, they are the very words prescribed.
So curious, because when it comes to priority seats, it has slightly different language, doesn't it? Page 21 of the full version we had this morning, Regulation 3, or clause, paragraph 3 of the schedule, there says there should be at or near a priority seat, indicating that disabled persons have priority for the use of that seat. So you've got two analogous situations with two different mandated...
Sorry, where is that?
That's page 21, internal 21 in this document.
Yeah.
Near the top of the page, 3.3, there should be a sign on or near a priority seat indicating that disabled persons have priority of the use of that seat. So you've got two analogous situations. You've got a fold-up seat in a wheelchair zone, or you've got a priority seat. In one case it says you've got to have a notice saying, please give this up to a wheelchair user. In the other, you've got to have a notice saying, disabled people have priority.
That's right, my lord. And what it shows...
It's difficult to imagine that the drafter actually intended a sort of different level of effectiveness to be given, isn't it?
Well, my lord, what it shows is that there is a level of prescription in these regulations, and a company which wants to comply properly with its obligations under them would be well advised to follow the words used in each given case. As
Also
we've seen,
well advised not to assume that by so doing that would necessarily fulfil all its obligations.
we don't say that necessarily complying with accessibility regulations one can assume, but we do say that insofar as complaint is directed at us for the words we used,
Oh, yes.
that is an unfair complaint with respect.
I think you follow the formula. There's no...
You follow the formula.
Well,
And
are you in a position also to say that if those are the prescribed words, it cannot be unreasonable to have a policy which is consistent with their less than absolute terms?
we do make that additional submission. We say that the prescribed words, first of all, enable us to answer the complaint that the language we used isn't tough enough, but secondly, are consistent with the policy that we, in fact, implement. Now, we have referred to it, and this perhaps answers the question that my Lord Toulson put just now. We have referred to our policy as a priority policy, and we respectfully submit that it is correct to refer to it as that. Why? Because we do, in fact, do something when a wheelchair user wants to board. We instruct the driver to ask the person using that space to make way for the wheelchair user, and the evidence is that generally happens.
The complaint isn't that you are in breach of these regulations.
No.
Well, I'm not quite sure why we've been looking at the regulations, other than to explain the wording, which I fully understand the strength of your point.
Yes.
What's said is you may be complying with the regulations, but they date from 2000. We've now got a new act, and that requires you to make reasonable adjustments. And the fact that you've complied with these regulations doesn't mean that you've therefore made reasonable adjustments.
Well, can I just unpack that question
Of
a
course.
little bit? The first point your Lordship puts to me is we've now got a new Act. Well, the Act that we have now contains materially the same duty as was contained in the Disability Discrimination Act 1995. These regulations were made under the Disability Discrimination Act 1995. So there is no doubt that these regulations were made at a time when the obligation that we're considering was in force, materially the same terms. The second point that your Lordship puts to me is a wider point, and that is that the mere fact that these regulations are complied with doesn't in and of itself mean that there isn't some further going obligation to be imposed under the guise of reasonable adjustments.
That's right.
And I accept the mere fact doesn't in and of itself make my case good.
You say it's
But
a
I
good
do
start.
say it's relevant
I understand.
to look at the type of language used in regulations made under this very Act or its predecessor.
And what you say is in relation to the sort of issue we're concerned with here, the present Equality Act does not take the law substantially further than under the 1995 Act.
No.
Thank you.
And my Lord Sumption put to me the point that I'm entitled to go a little bit further on the wording, and I would respectfully adopt that point. We are entitled to go a bit further because the use of words, which are words of polite request rather than peremptory instruction, as we've put it, it is consistent with what you find in the accessibility regulations. The second set of regulations which are relevant for these purposes are the conduct regulations. Now, my Lord Newberger put to my learned friend during the course of argument, well, what are we looking at these for at all? Why are they relevant if a duty imposed under the guise of reasonable adjustments can go further? And we say the answer to that is twofold. First, because in Part 4, and Regulation 12 in particular, they deal specifically and in detail with the question of when a bus driver is and is not under a legal duty to allow a wheelchair user to board. And we say that must be relevant to the very broad question of reasonableness, which is posed by Section 20, subsection 3 of the Act. And second, because in Part 2, they set out the circumstances in which a driver or a constable has a public law power to eject a passenger. And that must be relevant to the reasonableness of the adjustment, because otherwise you could potentially have an adjustment which the company is required to make under the Equality Act, but which it has no power to enforce under the general law. So those are the two reasons why we say that they are relevant. Now, can I just ask your lordships and your ladyship to turn up the conduct regulations?
Yes, of course.
They're in tab 2, Authorities Bundle 2, tab 23, MS 1604.
Thank you.
Now, the first point to make from these is that they were laid before Parliament and they were made after consulting representative groups. Now, the obligation to consult is, as you see from the preamble, in section 61(2) of the 1981 Act, which I think is not in the bundle, but we can provide it separately. That's where the obligation to consult comes from. Now, it goes without saying that when one has a public consultation on a set of regulations like this, the volume of material which is available to the legislator is much wider than that which is available to a judge in an individual case. Now, these regulations were first made in 1990, but as can be seen from the explanatory note, which is in volume 3, tab 24, MS 1641, top of the page, they were comprehensively amended in 2002 to insert a Part 4 imposing additional duties for drivers and conductors with respect to passengers who are disabled, including wheelchair passengers. And if one just reads on, Regulation 12, duties towards wheelchair users of Schedule 1 vehicles, adds new duties towards wheelchair users of regulated public service vehicles required to comply with the wheelchair accessibility requirements of Schedule 1 to the 2000 regulations. That's the accessibility regulations. So what that shows is that these regulations and the accessibility regulations form part of a statutory code. Directed specifically at wheelchair users of buses. Now, if we go back to volume 2, tab 20, page MS 152.2 as a further point to make here, which is that when these regulations were reviewed, and we'll come to see that they were reviewed very recently, the decision following that review was taken this year. But when these regulations were reviewed, the legislator, that's the Secretary of State, was under the duty imposed by Section 149 of the Equality Act, known as the Public Sector Equality Duty. And you have that at 1522. And that meant that the Secretary of State had to have due regard to the impact of any change to the regulations on disabled people, but also on other groups sharing particular protected characteristics, including, in particular, passengers travelling with young babies, the elderly, the very young. All of those groups are likely to share protected characteristics. You can see the protected characteristics set out in 1497 on MS 1523, age, disability, gender reassignment, pregnancy and maternity, race, religion or belief, sex and sexual orientation. So the ones that would be relevant here would be age, disability, and pregnancy and maternity. Now,
What page was that, sir? Sorry.
I'm sorry, that's 1523.
Oh, sorry.
These are the relevant
Yes.
protected
No,
characteristics.
I remember seeing them before. I just got the wrong.
Regard to which is
remember.
required to be had by Section
Yes, no, I
1491.
remember. Thank you very much.
Now, if we can go to the regulations themselves, and just take up the same bundle, Bundle 2, tab 23, Regulation 12, which is at 1623.
Yes. This is the one that Lord Reid referred to.
Yes.
Yep.
Now, Regulation 12.2 begins if there is an occupied wheelchair space on the vehicle. And then 12.3 defines occupied as including the case where passengers or their effects are in the wheelchair space and they or their effects cannot reasonably vacate it by moving to another part of the vehicle. Now, we say that you can get two things from this regulation. The first is that the language used in 12.3b shows that in the legislator's view, there could be situations in which a passenger or her effects cannot reasonably and readily move from the wheelchair space to another part of the vehicle. That's clear. We also say that it is reasonable to assume that the legislator had in mind situations where a passenger with a buggy couldn't fold it down, or if she could, couldn't stow it safely, so that there was nowhere else on the bus she could go. And the legislator decided not to impose a duty on the driver to allow the wheelchair user to board in that case. The second important matter that you can get from 12.2 is that there is no obligation to allow a wheelchair user to board if, in doing so, the maximum capacity of the vehicle would be exceeded. Now, the maximum capacity of the vehicle, I'm just going to tell you this for your note rather than taking you to it, if that's
Yes.
acceptable, are defined in Regulation 3 by reference to another instrument, the Public Service Vehicles Carrying Capacity Regulations,
Yes.
1984. And what they say, in essence, is that each vehicle has to have a certificate, and the certificate tells you
Yep.
what the maximum capacity of the vehicle is. Now, in this case, we have, and not only do they tell you that, but they tell you that there has to be a sign saying that
Yep.
in the vehicle. And we have, in this case, the sign that was affixed to this particular vehicle. It's in Appendix 2, internal page 621, MS 898.
Thank you.
So you can see the sign said
We saw that before, yeah.
64 seated and 27 standing, or 64 seated and 22 standing, and 1 wheelchair user passenger. So the maximum number of standing passengers depends on whether there's a wheelchair.
So you say if you've got 64 seated and 24 standing, and somebody with a wheelchair wants to get on the bus.
The regulations say, in those circumstances, the driver is not obliged to let the wheelchair user board. Now, if one applies the adjustment which the recorder identified here, of course, the wheelchair user would have to be allowed to board. And that would presumably involve, in your Lordship's example too, if there were 27, 5 other passengers having to get off the bus. Now, plainly, Parliament considered this very issue. That's what regulation, both the legislator and Parliament, when it was laid before Parliament, considered this very issue.
Yes, I see.
They asked themselves the question, what should happen when the maximum capacity is exceeded? And the answer was, well, no obligation to allow the wheelchair user to board. Now, if one imagines just for a moment that there is a superadded obligation, because of course we accept that in principle the duty to make reasonable adjustments can impose superadded obligations, but just to suppose for a moment that there is one, how is that going to be enforced? Who's got to get off? Has the driver got to then go to the wheelchair space and see who's standing there and ask them to get off?
Was it last in?
What if nobody's standing in the wheelchair space, but there are 27 standing on the rest of the bus?
I see.
How's the driver going to do that? Well, the answer is that these very difficult issues were contemplated, as said by the legislator, and the answer given was, in those circumstances, no obligation to allow the wheelchair user to board. Now, the recorder and the appellant both took the view, as my Lord has put during the course of my learned friend's submissions, that the content of the conduct regulations was simply irrelevant to the scope of the duty to make reasonable adjustments. The former simply imposed criminal obligations, whereas the latter imposed a separate and potentially farther-reaching civil obligation. Now, as to that, we make 2 points. The first is, regardless of the remedy, actually, in parentheses here, the remedy is a criminal, it does, breach of the conduct regulations does result in criminal liability, but there is a defence of reasonable excuse. So, actually, the criminal liability is a fairly minimal.
A qualified one.
It's a qualified criminal liability.
Yep.
But what we have in the conduct regulations is a carefully calibrated scheme of duties with respect to wheelchair users on buses. It could not be more specific to this case. We also have the fact that before the regulations were made, the legislator was obliged to have due regard under Section 149 and the consultation under Section 61(2). And we say when one puts all of those things together, it cannot reasonably be said against us that the content of these regulations is irrelevant to the very open-textured question of what's reasonable.
Yes, I see.
The second point we make is that the history of these regulations actually bears this out. And this was a point on which my learned friend made some submissions, which we say are not correct. If one looks at the fourth authorities bundle, tab 34, MS 2122, this is the public consultation document which was issued in October 2014, and it was part of, as you see from one looks at 2122 paragraph 1, part of the red tape challenge. So we want to try and get rid of regulation where regulation isn't required. That was mentioned by my learned friend. Now, going forward in that document to 2133, and in particular paragraph 1.27, you can see that the Department of Transport had noted that it had considered making significant amendments to Part 4 of the regulations, that's the part about wheelchair users on buses,
Yes.
on the basis that they were unnecessary because of the Equality Act duties. But the government decided against making changes because, see 1.28, these regulations comprise the only detailed legal requirements made as recently as 2002 concerning the specific legal requirements for drivers and conductors in respect of all disabled passengers on a public service vehicle. And then it went on to say that relying instead on the Equality Act might lead to a lack of clarity on certain bus-specific issues.
Yeah.
Now, in its response to consultation, which you have in the next tab 35, at page 2148, this was a response to consultation which was issued in January of this year, after the Court of Appeal's decision in this case. And what you see from paragraph 1.17 to 1.19 on 2148 is that the decision that the government had noted that some of the respondents to the consultation had asked for amendments to the conduct regulations following the recent Court of Appeal decision in this case. But the decision was taken to maintain them in existing form. So we do say that this is not, and this is a further answer to the question that my Lord Neuberger put to me, well, aren't these really rather old regulations and say nothing? First of all, they were made under the power which is materially the same now.
Yeah.
And secondly, they've been reviewed as recently as this year and a decision taken not to change them, even though people were writing in, following the Court of Appeal decision in this case, and asking for changes.
Yes.
Next, my lords, my lady, there is part 2 of the conduct regulations. So if we go back to the conduct regulations themselves, part 2 is the part which governs the conduct of passengers.
Where do you want us to look?
And that's Authorities Bundle, back in Authorities Bundle 2, tab 23. I'm sorry, before we go to 22, if we can just look at tab 22, MS 1600.
Thank you.
This is the primary authorising power.
Yes.
And it's section 25 of the Public Passenger Vehicles Act 1981. And you can see from Regulation 25, regulations may make provision generally as to the conduct of passengers on public service vehicles or tram cars, and in particular, but without prejudice to the generality of the foregoing provision, for authorising the removal from a public service vehicle of a person infringing the regulations by the driver, etc., or on the request of the driver by a police constable. So one question raised by the court below was, well, wouldn't there be some common law power to remove someone who remained on the bus in breach of the conditions of carriage? We would say it's a sufficient answer to that it is far from clear that there would be such a common law power, but at any rate, it's plain that Parliament took the view in section 25 that there was a need for an express statutory power. And now that that express statutory power has been provided in the form of Part 2 of the conduct regulations, it would certainly be a bold, and indeed we would submit foolhardy, bus company that instructed its drivers that they could lawfully remove a passenger in circumstances not expressly authorised by the regulations.
Yep.
Now, the regulations themselves are in the next tab, tab 23, and it's been pointed out that Regulation 8 gives the power to remove.
Page?
That's on page 1620.
Thank you.
It confers that power on either the driver or a police constable acting at the request of the driver. But the trigger for the power is contravention of the regulations.
So that brings you back, you say, to the same point.
Yes.
Yeah, I see.
Now, the regulations could have imposed a general prohibition on remaining on the vehicle when directed to leave by the driver. It's perfectly possible to imagine regulations
In
framed
accordance
that-
with the policy of the particular company or something
Exactly.
like that, yeah.
Something of that kind.
Yep.
They didn't do that. What they did in Regulation 6.1k is they prohibited a passenger from remaining on the vehicle when directed to leave by the driver, inspector or conductor, this is 1615,
Thank you.
on the following grounds, and then they are enumerated, 1, 2 and 3. Now, this regulation, Regulation 6, was in the original 1990 version, but it was also amended in 2002 when Part 4 came in. So this isn't a part of the regulations that have simply been left alone. You can see that from looking at 6.1 capital A,
Yes.
6.3 capital A.
Yeah.
These are amendments made in 2002. But the amendments did not alter the list of circumstances in which a passenger was prohibited from remaining on the vehicle. They kept the same circumstances that you see in 6.1k.
Yes.
Now, to get around this problem, Mr. Allen relies on a number of provisions directed at unreasonable and antisocial behaviour and nuisances.
Yes.
So there's 6.1b, no passenger on a vehicle shall put at risk or unreasonably impede or cause discomfort to any person travelling on or entering or leaving the vehicle. And then there's 6.1k, 2 and 3,
Yes.
which prohibit passengers remaining when directed by the driver to leave on the ground that they've been causing a nuisance or on the ground that their condition is such as would be likely to cause offence. Now, my lords, lady, doubtless there are cases where people in the wheelchair space will cause a nuisance within the ordinary meaning of that phrase, or will unreasonably impede other passengers. One can have a group of unruly passengers in any part of the bus. There is no doubt that the driver has power to eject them in these circumstances, but that power is not specific to the use of the wheelchair space, and so is rightly not referenced in FirstGroup's policy on the use of that space. The difficulty with applying these powers to our case is that none of them applies unless the passenger's behaviour is unreasonable. But the regulations, as my Lord Reid put to my learned friend, have to be read as a whole. And we know that Regulation 6 was amended at just the same time as Regulation 12 was inserted. And if the suggestion is, and it seems to me it would have to be, on this aspect of my learned friend's case, that any refusal to vacate the wheelchair space is necessarily unreasonable, that suggestion is simply inconsistent with Regulation 12, which deals in detail with the position of wheelchair users and makes clear that there are situations in which it is not reasonable to expect a passenger or their effects to vacate the space. Now, one can come to a list of different examples, and we will come to that in just a moment when I look at the practical difficulties. And there are examples given not just in this case, but also by the Judge Bowers, in the case of Black, which I'll come to in a moment. But just take the paradigm case of a person with a buggy with a child in it who politely declines to move from the space. We say it is just not sensibly arguable that such a person could be regarded as causing a nuisance or indeed as unreasonably impeding any other passenger when one reads this regulation in accordance and consistently with what you see in Regulation 12. Finally, there is Regulation 6.2, which deals with articles of various different kinds, including bulky or cumbersome articles. Now, the Court of Appeal dealt with this at paragraph 48 of its judgment. I don't ask your lordships, your ladyship, to turn it up necessarily at this point. What was said there was that even if some large pushchairs might conceivably qualify as bulky or cumbersome articles, when empty, it's quite difficult to see that a pushchair with a child in it would qualify as a bulky or cumbersome article, particularly when one reads Regulation 6.2 with Regulation 6.1k, which sets out an apparently exhaustive list of grounds on which someone is prohibited from remaining on the vehicle. But in any event, we also make the point that my Lord Reid put in argument, which is that 6.2 also has to be read consistently with 12, 12 being the specific provision that deals with wheelchair use. So we do say that for both of the two reasons I gave at the outset, the conduct regulations are highly material to the question of reasonableness. They're material because they show, by way of detailed consideration, what the legislator thought was reasonable in this precise case, and they're material because they show that if the adjustment identified by the recorder were made, that is to say, FirstGroup adopted a policy of always requiring and enforcing someone in the wheelchair space to vacate it, that there is no obvious basis on which they would have a legal power to do that. Now, one point that was made against me was, well, of course, enforcement is only the last line of defence. There are a whole set of changes, my learned friend said, that go to the culture. And one would hope, and this is what the recorder found as well, that it wouldn't be necessary to get as far as enforcement in most cases, because once you'd clearly changed the rules, one could see what the rule, every passenger could understand what the rules were, and it wouldn't be necessary in the vast majority of cases to get to the stage of enforcement. But a key plank in my learned friend's argument is that the possibility of enforcement must exist. If the possibility of enforcement doesn't exist, then all the rest of my learned friend's adjustments, which lead up to that in an extreme case, fall away, because everybody knows that when a request is made, there is no way of backing it up. And that's the difficulty that FirstGroup faced when it formulated its policy. And you've seen the policy. The policy says, request the person to move, but ultimately, we can't make them. And if that is the position, there's no point pulling the wool over anyone's eyes about it. That is the position, and people will learn that that's the position very quickly. Now, can I move to my fourth head, which are the practical difficulties flowing from the recorder's judgment? Now, I am going to make reference, when I look at these practical difficulties, both to the evidence in this case, but also to the findings of fact made by the judge in the black-linked cases. I'm going to do that because, as I said at the outset, it would be unfortunate, to say the least, if this court were to decide this case on the basis of what had been the arguments that had been put before the recorder in this case and no other arguments, when there is another first instance judgment, which might, for all we know, be legally correct, which says precisely the opposite. That's why the Court of Appeal took this case, and that is no doubt why this court took this case as well, because bus companies such as First need to know what they are required and legally empowered to do. Now, can I deal then with the problems? We've set them out in our case, starting at MS 127, and there are three categories of problem, if I can put it like that.
Yep.
The first is that we've headed others using the wheelchair space, and what we mean by that is implementing the adjustment that the recorder identified here impacts on the legitimate interests of others using the space and may do so unfairly in particular cases. The second type of problem is confrontation and delay, and the third, which is linked, is enforceability. And by enforceability, I mean to include not just legal enforceability, but also practical enforceability.
Yes.
And I'll come to that in a moment. Now, if we start with the position of others using the wheelchair space, as I've said, my lords, lady, the adjustment identified by the recorder would require FirstGroup to require any non-wheelchair user occupying the space to vacate it if required by a wheelchair user. Now, we've set out the categories of person who'd be disadvantaged by this adjustment at paragraph 73 of our case, and this is on MS 128. Now, some of these are cases where the non-wheelchair user is herself or himself disabled. She may, as in A, need the space to store a walking frame, or as in C, be unable because of a disability to hold a child on her knee. The latter example, by the way, comes from an inquiry made by a real passenger to FirstGroup concerned about the effect of the first instance judgment in this case. Now, these are cases where the non-wheelchair user's need for the space arises because of a disability. But the same need to use the space might arise because of a medical condition falling short of a disability, such as an injury caused by an accident. Then there are cases, such as B and C and E, where either the pushchair cannot be folded, or if it can, there's no space for it other than the wheelchair space. So if the wheelchair user is to be allowed to board, the non-wheelchair user has to get off.
These cases are covered, aren't they, by Regulation 12 of the conduct regulations, as you would say, that those are situations where the wheelchair space is occupied within the meaning of the regulation. Therefore, the would-be wheelchair user has no right to board, and since they have no right to board, no question can arise in relation to discrimination against them.
Well, my learned friend would no doubt say, we do say that these cases are covered by Regulation 12.
What about the converse? If the space is not occupied within the meaning of Regulation 12, so that there is a right to board, the argument against you is, well, then reasonable adjustments have to be made to make that as effective as possible. And one way of doing so is to say, as Stagecoach do or Lothian do, others are required to give up. And even though that may not be fully policeable, half a loaf is better than no bread.
Well, I'm going to come to Stagecoach in a moment under enforceability, if I may, because we do say when one looks at enforceability that, as the judge in Black found, there was no evidence of any company actually enforcing these requirements. I'll come to show you that as well, both by reference to that and also by reference to Lothian. So can I address that when I get to enforceability? Certainly we agree that if the wheelchair use space is unoccupied within the meaning of Regulation 12, then the conduct regulations impose duties which are enforceable under the criminal law, subject, of course, to the defence of reasonable excuse. It is very difficult to think that a driver could be prosecuted for failing to comply with Regulation 12 if he had done what drivers are required to do under this policy, That's to say, to request a wheelchair user to move, a non-wheelchair user to move, and the request is then declined. Particularly if, as we've said, there is no power under the conduct regulations to enforce that. The question would be asked, well, what was I supposed to do? Now, I've talked about cases such as B and E, where the pushchair can't be folded, or if it can, it can't be stowed. Then there are more run-of-the-mill cases of the kind described by the judge in Black. And can I just show Lordship's Ladyship what was said in Black at paragraph, at bundle 4, bundle 1, tab 4. MS 1008. This is the judgment in Black. Now, we go forward to paragraph 46. At page 1018, there are a number of cases described there. Now, some of them are cases where the person in the wheelchair space doesn't move because there's a sleeping baby in the pushchair. Then if you look at the first indented paragraph in the second column of 1018, it is also noteworthy that the lady in the incident on the 24th of January 2012 said that she would normally get off to allow Mrs. Elliott to board, but could not because her baby had an important appointment with the doctor. Now, even leaving aside the case of an important appointment, the judge was obviously alive to the difficulties faced particularly by passengers travelling with very young babies, and he deals at 61 and 63 with the difficulties faced by passengers folding a buggy while carrying a young baby who can't be put down, and at 63 with the difficulty of having to wake very young babies. Now, we understand by the adjustment identified by the recorder that we are required to cause the passenger to vacate in all of the cases that I've just mentioned.
Well, I'm wondering about
But
that,
if
because
not...
The recorder wasn't... No submissions were advanced to him on this area, so his judgment is silent on it. You have raised a point, and you raised a point, really, in a variety of circumstances where the wheelchair space is occupied, and therefore there's no right to board under Regulation 12. That might be the beginning and the end of it. But
Yes.
I don't think you can say that the recorder's judgment covers situations about which no argument was made.
Well, the trouble with that, my lord, is that puts to me, that posits a totally different adjustment from the adjustment that the recorder actually identified. So it posits an adjustment which says you must adjust your policy so that the driver must consider in each and every case whether there is a good reason for the passenger to move. Well, that posits that adjustment.
The driver's going to have, since he has a duty under regulation or clause, whatever it is, paragraph 12, there will be circumstances where he has to consider does 12 apply in order to decide whether he's under an obligation under it.
Well, not necessarily, my lord, because that depends on whether the policy that currently is implemented by First is sufficient to avoid criminal liability, and we say it plainly would be. It'd be sufficient to avoid criminal liability because you would have a reasonable excuse for failing to cause someone to move if you would ask them to do so. Now, if what your lordship is putting to me is that as a result of obligations imposed by the civil law, the reasonable adjustments obligation, actually what FirstGroup had to do is to get its drivers to try to work out in each and every case whether the person in the wheelchair space had a good reason to be there or not. That would have been a totally different adjustment, but it would have been a manifestly unreasonable one.
I think what I'm suggesting to you is two things. One is that you're raising a variety of situations which weren't put to the recorder, but which would seem to have the common ground that there's cases where there is no duty to let the wheelchair user on the bus at all, because because of Regulation 12.
Well, my lord,
That may be the beginning and end of that point, but I'm putting to you a second point, which is you say, oh, well, that involves the driver having to think about whether paragraph 12 applies or not. Well, I'm saying that surely there are circumstances where a driver will have to consider whether Article 12 applies or not, because it bites on him, and he may have to consider whether it bites on him.
Well, my lord, what we say to that is this, that FirstGroup's current policy is that when a wheelchair user wants to board, the driver asks the person in the space to leave. And if the answer is no, he doesn't take matters further. That's the current policy. Now, we say that is a policy which does not realistically expose drivers to criminal liability under the regulations. Now, if your lordship is putting to me that actually the submissions in this case were directed to the facts of this case, I agree, they were. They were directed to the facts of this case. But we are here in the Supreme Court trying to work out what bus companies have to do to comply with the law. And what the recorder actually found in this case is that the statutory tort committed by the defendant was the tort of failing to adjust its policies so as to require and enforce access to the wheelchair space, full stop. Now, even if we take this case, one doesn't find in the recorder's judgment any consideration of whether this was a case where Regulation 12 would have applied or not. There wasn't cross-examination on the question of whether the woman had a good reason to be in the space.
Well, his approach was that Regulation 12 was completely irrelevant anyway.
Indeed, indeed.
No.
And we say quite wrongly.
Yes.
So, my Lord, we do say that Regulation 12 is relevant,
Be wrong.
but it cannot be the case that it is necessary for the driver, and if the driver fails, then there is civil liability, to consider on the facts of each case whether the passenger has a good reason to move. Now, this, as you've seen, the woman in black was going to a medical appointment. Well, what about if it was an appointment at the benefits office or at the council about her housing? Or one can posit a whole range of other reasons why someone might have that they don't want to move. Is it really being suggested that the driver has got to adjudicate and arbitrate in these cases between what may, on the face of it, seem to the individual occupying the space to be a good reason to remain there, and other cases?
In that case, under Regulation 12.3b, which treats the wheelchair space as being occupied if passengers or their effects cannot readily or reasonably vacate it. Suppose that the judge concludes that the person occupying the space cannot reasonably or readily vacate it, but the court subsequently concludes otherwise. Is he committing a criminal offence?
Well,
He does have to form a judgment on that.
He's got, of course, the defence of reasonable excuse,
Yes.
which is an important point.
So if his view was a reasonable one, you say he would have a defence,
Yes.
even if a court took the view that it was wrong.
Yes, we do say that, and I mean, if one asks the question, well, did you have a reasonable excuse for not complying? And the answer was yes, my reasonable excuse was that I tried to persuade the individual to move, but they wouldn't do so. That would, on any view, in our respectful submission, be a reasonable excuse. such as to absolve the driver of criminal liability. So the question that Your Lordship and my Lord Toulson puts to me of, well, surely you've got to make these judgments anyway, is we respectfully suggest not a fair one. And it is open to us to say that if the recorder really, if the recorder's adjustment means not you must always let someone board, but you must let someone board unless the individual occupying the space has a good reason to be there, that is an absolutely impossible adjustment to make and an absolutely impossible position to put drivers in. Now, the second head of problems, which we've dealt with...
Just ask one thing. The example which you gave us a moment ago,
yes,
of a person taking a sleeping baby to a hospital appointment, anxious not to wake the baby.
I think it was a doctor's case.
That situation where there was no... Is that a case where there was nowhere else on the bus to move to?
Well, we don't know. We don't know.
I mean, because if the bus is full, the situation doesn't arise, does it?
Yeah. Well, all we know is what was said in black, and what was said in black was the woman would normally get off to allow a wheelchair user to...
For your purposes in advancing it as an illustration, are you wanting us to envisage a situation where the bus is full and she's nowhere to move to, or where the bus isn't full?
Well, you've got to assume that if the wheelchair user was to board, she would have to get off. That's clear from what's said by His Honour Judge Bowers at 46 in black. He says the woman would normally get off to allow a wheelchair user to board, but she didn't want to do so on this occasion because she was taking her baby to an important medical appointment. So you've got to assume that's the case. And that could be either because the buggy doesn't fold, or it could be because the buggy does fold, but there isn't anywhere else to put the buggy.
The point is that she, for one reason or another, she can't travel except in the wheelchair area.
Yeah,
In which case, within the meaning of regulation, it is occupied.
that's right.
Yes. And in which case,
and in our case,
the wheelchair user has no right to board.
Yes, but that might be right. But even the case that my Lord Reid put in the course of argument this morning, i.e. the case where there were heavy suitcases, could also be a case where where the wheelchair user has no right to board.
Yeah.
Yet, nonetheless, Regulation 12 says that in such a case, no obligation on the driver to allow the individual to board.
Right. So if the regulations are relevant, as you say, that governs the accessibility and governs his or her entitlement to board.
Yes.
Yeah.
Say that. Actually, this case, if one just moves it from these facts to our case and asks the question, well, is this a case where Regulation 12 would confer a right to board? The answer is we don't know. Nobody made any findings of fact on that because the recorder had not identified any adjustment which required the driver to make these sorts of finely tuned judgments. The recorder identified a rigid adjustment of requiring whoever was in the wheelchair space to vacate the space and enforcing the requirement.
Yep.
Can I just ask you, you said it was a defence of reasonable excuse. I was having trouble finding it.
It is section 68.1. I think I'm right in saying it may not be in the...
Of the Principal Act.
Of the Principal Act.
Thank you very much.
Yeah. Now, we have dealt briefly with the questions of confrontation and delay in our case. Can I just give you some references to that? It was put... First of all, this point is dealt with by Judge Bowers in black at 86 to 87 and 89.
Where is this in your case?
This is...
Paragraph 80, is it?
Paragraphs 80 and following. There was also evidence in this case, which I'm not going to ask you to turn up, I'll give you the reference. It's Appendix 1, MS 422, where various points were put to the driver in this case.
Yes.
And it was suggested to him, well, you've got these powers to remove people who are eating
We've
smelly
been through
food.
this, we looked at it.
Yes. You've got powers
Mr.
to remove
Allen.
people who are eating smelly food and
We've
so
been-
forth.
we've looked at this, yeah.
And his answer was, well, there's a lot of difference between a kebab and a newborn baby. So that puts the point perhaps more pithily than I could. The final difficulty is one of enforceability. Now, I've already made my submissions on the legal aspects of enforceability. We say there is no obvious or clear power in the conduct regulations to cause someone who politely declines to leave the wheelchair space to vacate it. But even if there were a power to eject, there is a practical aspect too. How is the driver actually going to eject someone who other passengers might reasonably consider had a real need to use the space? If he is supposed to stop the bus and wait for the police, is it really going to be to the benefit of anyone, including the disabled wheelchair user? Now, can I deal next with the recorder's suggestion that there are other bus companies which have a priority policy with teeth? We say, we deal with this at paragraph 20E of our case, MS 112.
Thank you.
Can I show you, first of all, the recorder talks in his judgment about London and Lothian. My learned friend says that must have been a mistake. But can I just show you for completeness what the London policy is? It's Appendix 2, and it is page 475. And this is called the Big Red Book, which is a book of policies used by in London. You can see, second bullet point, it can be stressful travelling with children in buggies, so be polite, as this is more likely to get passengers to cooperate.
Sorry,
Perhaps-
where are we?
It's the bottom of page 475.
I'm sorry, 475 MS 752.
Oh, right,
Sorry,
well.
I gave you the internal page and not the MS number.
752.
752.
Thank you.
So second bullet point, it can be stressful travelling with children in buggies, so be polite, as this is more likely to get passengers to cooperate. Perhaps supplies the evidence that my Lord Sumption said was missing from the transcript that we looked at earlier. Explain you'll give them the time they need, etc. Then fourth bullet or point underneath that, if passengers are unwilling to move despite your request, do not ask them to leave the bus. Do not close the doors and move off until you've explained to the wheelchair user, etc. So that's Transport for London's policy. The same, I'm not going to go to it, but I'll just give you the reference, emerges from Thames Downs policy in Swindon, which you have in Appendix 2, Internal 519, MS 796. Now, as to Lothian, its conditions of carriage were before the recorder, and you've seen them.
Yes.
They use the word must, but
Yes.
there is nothing in those conditions of carriage that indicates that Lothian considers that it can, or that it does, in fact, enforce the requirement.
Can you remind me of the page number?
Yes, MS 784.
Thank you.
But there was evidence about this very point in relation to Lothian in black. So if one looks at volume 1, tab 4, it's dealt with in a number of different places. First of all, at 30 in the judgment, he makes clear that he's been directed to the policies of other operators such as London, New York and Lothian. 44 at MS 1018, he says he has no evidence to show that any of these other operators has been able to enforce the rule and compel a passenger to vacate the space against his wishes. Then, at 78...
Sorry, which paragraph was that?
I'm sorry, that was at 44.
44, thank you.
Then at 78, and this is important, we respectfully submit, on page 1023, he says this: it is of note, first indented part of 78, that even Lothian buses accept that no passenger can be forced to leave the bus even if they decline the offer of an onward ticket. And he gives references to the evidence that was before him.
Yep.
Now, my lords, my lady, FirstGroup specifically challenged the recorder's reliance on the Lothian policy on the basis that the evidence before him did not show that the policy was actually enforced. And in the Court of Appeal, we put in a note, I'll just give you the reference to that in a moment, at the invitation of the court in reply, dealing with this point, and we made clear that we did not understand the appellant to submit that that the documents before the recorder actually did show that Lothian enforced its policy. And we invited its page, MS page 406, paragraph 6. And we invited correction if we were wrong about that. There was no correction, so the Court of Appeal must be taken to have proceeded on the basis that that was not being put. Now, my lords, we have here, and I mention at this stage that Mr. Allen objects to your having it, a document from Lothian's website, which was not before the recorder, but we have copies of it here, and I am
Mr.
going
Allen,
to...
I think we should probably look at it de ben essay, should we, or would you object to that even?
Well, my lord, I've got points to make in reply about extra
No doubt,
facts
but
to be
I'm
made.
just asking you if you object to us looking at de ben
My
essay.
lord, I don't think it is appropriate for you to look at it, is the answer. No, because I object to having to meet a case which is not argued below and which I've not been able to challenge or explore in any way at all. Now, I'll give my reply submissions in relation to the point about the Court of Appeal. I don't think it's appropriate, my lords.
I think you did mention before the short adjournment researches that you had conducted.
I made it perfectly clear that all of that is in the bundle already and had not been the subject of objection, my lord. But there it is. I've made my objection. I don't think it is appropriate.
My lords, not only did he mention researches he'd done, he also invited you to look at Stagecoach's conditions, which, as he said in his submissions to you this morning, were not before the recorder. So I am going to invite your lordships and your ladyship to look at this document, de bene esse. If my learned friend has a valid objection, no doubt you will put it out of your minds on that basis.
Yeah, we will look at it de ben esse. I have my doubts as to whether it will make any difference to the outcome.
Well, it may
of
not.
this case
It may not. But we do.
Seems unlikely that the whole case is going to turn on it.
We'd probably, but
these things get quite tense in court sometimes.
we do think that it is important with respect.
Well,
that
we
you have the court picture.
will look at it as we indicate, but
Can I
make it
just
quite plain that we're not.
tell you what it is?
Yep. Well, we will like to see what it is. I think.
Yeah, it's called Accessibility FAQs, frequently asked questions, and it comes from Lothian's website.
Right.
It was uploaded to Lothian's website on the 27th of June 2012, and it appears to be the document that was before Judge Bowers in the Black case. What we can see from the middle
So
of
if
the
we're
first...
applying the normal standard of fresh evidence, you could have got it for the hearing in front of the recorder.
Yes.
That may be a fair point.
Thank you. Very well.
So
Yes,
what it
anyway, well,
says
let's look at it
is-
very quickly. What is it you want us to look
It's
at?
the middle of the first page,
Right.
just under the first hole punch.
Yes.
Wheelchair users have... Sorry.
I was adding insult to injury, and Mr. Allen hasn't got a copy.
Well, yes,
Now he has.
he has had it, because we have had correspondence about this document. All of our buses have electric ramps, etc. Wheelchair users have priority of access to the wheelchair space, and other passengers must move to make it available when a wheelchair user needs it. However, we can't guarantee that all passengers will move from the wheelchair space when asked, nor ultimately can we force them to do so. So, my lords, that makes, we would respectfully submit, our point that there is a difference between putting something in your terms and conditions and actually having a practice of enforcing them.
Yes,
So
but
when
simply because you can't enforce them doesn't mean to say that there is no value in making it a requirement. As Mr. Allen says, we're about changing the culture, changing attitudes here.
Absolutely, I understand the point, my lord, but when one's actually looking at what the adjustment is that's been identified here and asking whether it's going to make a difference, this is a document. Here is Lothian saying, we have terms and conditions which say you must move, but we're telling you on our website that we can't make you do so. Now, how is that actually, in substance, different from what FirstGroup does? FirstGroup has a policy which you've seen, which says, well, we're going to ask our drivers to request you to move, but we can't make you do so. There really is no difference in substance at all. And
I think
actually,
that's a matter for
and
individual
actually,
judgment, I think.
Actually, my lord, when one looks at how the recorder dealt with this at paragraph 5 of his judgment, that's the approach that he took too. What the recorder said was, I'm not really interested in whether your policy is a policy of priority or not. I actually want to know what you do to enforce it. And the recorder took the view that, well, we don't do enough because we ought to actually enforce it. We ought to cause people to leave the bus. Now, if the position really is, as Lothians say, well, ultimately we can't enforce it, then their policy is really, in substance, the same as ours. Now, what do we say about Stagecoach? Again, we say exactly the same about them. Their policy is plainly one which uses words which are more peremptory than ours. But again, absolutely nothing in the policy to indicate that it is their practice to enforce that policy either generally or in any case.
Right, I think...
Now, finally, my fifth heading, which I'm going to do actually just by reference to our case, by giving you the references, because I can see the time, are the alternative adjustments which my learned friend relies on. Now, if we just take up my case at paragraph 110, you can see what the alternative adjustments are. Page 139.
Thank you. Yep.
We deal with them at 111.
Yes, that's right.
Can I just give you some additional references to black on each of these?
Yes.
The first adjustment is one that says you must make clear to customers... I'm sorry, this is at 140, MS 140.
Yes.
First adjustment is make clear to customers that they must fold their buggies. Well, that was dealt with in detail in black at 43 and 65, MS 1017 and MS 1021. Second adjustment, which we deal with, is train drivers to persuade the passenger to move from the wheelchair area. Well, you've already seen what Lady Justice Arden said about this. Absolutely not the subject of discussion below. But in any event, dealt with in black.
Both of you seem to be taking that point when it suits you.
Yeah.
My lord?
Both of you seem to be taking that point when it suits you.
That's
Nevertheless.
probably a fair criticism. But your lordships have seen, and your ladyship has seen what Lady Justice Arden had to say about it. Also dealt with at black, adjustment 7 in black at MS 1022. Then the third adjustment was, again, requiring passengers to fold their buggies before they board. Again dealt with in black at 57, MS 1020. And the last one was instructing and or training drivers how best to accommodate. Again dealt with in black at 72, at 1022. So we say for all those reasons the appeal should be dismissed.
Could you just tell me, I have no doubt missed it, obviously we had two inconsistent county court decisions.
Yes.
We got Paulley and Black, and that's how this case ended up in the Court of Appeal.
Yes.
Was there an appeal in Black?
There was, but it was withdrawn.
It was withdrawn,
Yes.
and are we allowed to know why it was withdrawn?
I don't know the answer to that, but I think it may have been funding issues or something of that kind.
Well, if Mr Allen knows the
Mr.
answer
Allen.
and thinks that it's something that we ought to know, I mean, it would help me certainly to.
Mr. Allen knows the answer. I'm afraid I don't. Unless I can assist further, those are my submissions.
Thank you, Mr. Chamberlain. Mr. Jones. Thank you. Mr. Allen.
Thank you, my lords. Would your lordships be kind enough, please, first of all, to pick up the core bundle and to go to page MS 480. And keep a finger in there, but just to identify what the document is, 468.
Yes.
You'll see at 468, claimant's preliminary skeleton submissions. At page 480, at paragraph 27, Ms. Casserly wrote this: "It's understood that the defendants may be placing reliance upon Black and Arriva, the judgment of the Middlesbrough County Court. The claimant submits that this decision is not relevant, as the facts and indeed the legal arguments relied upon are different. In any event, it is a first instance decision." Mr. Hodgson didn't have a copy of Black. Miss Casserly sent him a copy, as was her duty as a counsel. He made it perfectly clear he didn't rely on any of it at all in the argument in front of the recorder. Mr. Hodgson could not have made any of the submissions relating to Black that you've heard from Mr. Chamberlain in the course of the last 30 minutes. Not one of them could he have made. The reason why Black was not appealed was because it was argued wrongly at first instance. It was not put forward that the duty to make reasonable adjustments is an anticipatory duty which looks at the effects generally on a class of persons. Because it wasn't approached in the right way, the focus was always in Black on the individual cases of disadvantage rather than the effect of the PCP and whether or not there could be adjustments to the PCP, and if there had been, whether they would thereafter have been detriment that would have been caused to the individual complainants in the Black case. I could not have argued Black in the Court of Appeal on the basis that it had not been properly argued the first time round. The duty to make reasonable adjustments as an anticipatory duty had not been put forward, and therefore I advised that it should not be argued. It's not argued properly below. I couldn't re-argue it in the Court of Appeal. It's as simple as that. And that's why, quite properly, Ms. Casserly put the case in front of the other side, and they didn't rely on a single fact in it. Not a single one.
We have the point.
Complete answer to the point. No doubt it's why there's a change of counsel. So that's the answer about Black. I'm not going to go through all the different paragraphs because it's quite sufficient to put it that way. There was no reliance placed on any of the evidence adduced in it or any suggestion that it gave the answer to the case that is currently before you. The second point I want to deal with is my friend's arguments about Regulation 12 and Regulation 6. As my Lord Toulson has said, Regulation 12 does define when there is a legal right to get on a bus and when not. If there's no legal right to get on a bus, there's no legal right to have a reasonable adjustment. It's as simple as that. You can't get round that. If there is a right to get on a bus, then there's a duty to make a reasonable adjustment, a general right, there's a duty to make a reasonable adjustment accordingly. The argument that my friend put forward about Regulation 12 and about the difficulty, that the way that they resolved the difficulty so that bus drivers don't have to consider and make decisions doesn't stand up to scrutiny. On his case, provided the bus driver has asked somebody to move, they have a reasonable excuse defence under Regulation 12. Let's consider a couple of examples. Suppose you've got the Wetherby under 13 football team. It's a five-a-side football team. They all fit in the wheelchair space. They're taking one stop on the bus from the football pitch back to the school. Bus driver has a completely empty bus, but they all want to stay in the wheelchair space and talk to each other and play Pac-Man. They're not making a nuisance in the way that he says it. Apparently, the bus driver can deal with this by simply asking them to move, and if they say no, he's got a complete excuse. He can rely on the policy. It simply does not make sense that he can rely on Regulation 12 in that way. It doesn't operate in that way. It's clearly a stricter and more difficult duty. Suppose they'd got their football kit with them. That doesn't make it any better. He's still got a power under the regulations to say where the kit should be moved to, that it's got to be put in the space. But if they refuse to do it on his basis, there's a complete defence and the wheelchair user can't get on. If that football team is watching these proceedings and have read the Court of Appeal judgment, they will know they could play havoc with Mr. Paulley's journey. They could stop it happening. Regulation 12 cannot be read as preventing the duty to make reasonable adjustments. It simply is a criminal proceedings. It defines in certain circumstances when people must be admitted, but it can't be read in a way that undermines the duty to make reasonable adjustments. And that's why the recorder dealt with it in the way that he did in his judgment. It doesn't resolve the issues that are in front of you. My friend also dealt with Regulation 6. You've got our submissions on that. We simply say that Regulation 6 is replete with possibilities for enabling the bus company and the bus driver to enforce a policy of require, not request, as the recorder said. He couldn't answer the point about it being a nuisance. If somebody is told in terms that the company policy is to admit and to give priority use to the wheelchair user, the mere fact that the refusal is given politely doesn't stop it being a nuisance and doesn't stop it being in breach of the other provisions of Regulation 6 that I cited you this morning. It might seem unfair to the individual if they've been polite in response, but if actually the bus is to be used and run in accordance with a policy such as stagecoaches, then there's a breach of Regulation 6, and they should be told so. Their name should be given, and they should be asked to move in those circumstances. The next point that I wanted to deal with is his suggestion that somehow, because the public sector equality duty is taken into account in the formulating of the Regulation 6 policy, that's a point in his favour. On the contrary, we would submit we would suggest it must, given the content of the duty, Section 149, it must actually mean that it was thought that Regulation 6 in its amended form assisted wheelchair users, not undermined their ability to get on the bus. It's a point in our favour, not the opposite. He sought to draw favour from the fact that the conduct regulations had been reviewed. They have indeed been reviewed. But as I said this morning, they could not have been made more onerous in the context of that review. And I'll show you the consultation document made this perfectly clear, if I can just find it.
This is the red tape review.
That's the red tape review. Thank you.
And the point you made earlier was
Paragraph-
that it was all about taking away requirements. It was not about adding to them.
Exactly so. Paragraph MS 2123 in tab 34. This is what it said. It should be noted that as this consultation is being carried out as part of a red tape challenge commitment, the Department for Transport is looking to reduce overall domestic regulation rather than add to it. With this in mind, we will not consider suggested amendments to the conduct regulations that actually represent an increase in regulatory burdens on either the bus industry or the general public.
Thank you.
So that's it. That's it. Doesn't advance his case one whit. The truth is that what has happened is that this bus company has come on appeal to the Court of Appeal and now tries to come to this court to get this court to try and set out in the broadest possible terms what policy it can and can't have. The place for it to make those arguments was in front of the recorder. The burden of proof was on them. Mr. Chamberlain's submissions in relation to the burden of proof were entirely fair and completely reasonable. The burden was on them. He accepted that we had done enough to reverse that burden of proof. And they did not do anything to engage with it substantially, as the recorder found. My Lord, I think that brings it in on time.
That was very...
Oh, I'm being told one thing. Will you allow me?
Of course.
Yes. And one point of correction, I should say, it was not until 2005 that there was any duty on reasonable adjustment in relation to the transport industry. It's not correct that the amendments to the conduct regulations took place at a time that there was a duty on the transport industry. Thank you.
Thank you very much. Well, thank you very much for your respective, very effective, clear arguments. Thank you also to all those involved in preparing the written cases, which we found helpful. We will consider this case obviously very carefully and let you have our decision in due course. Thank you all very much indeed. The court's now adjourned.